impact statement, the defense may have known.
Not far at all. It was the first day. It was on direct exam. She had volunteered information in response to a Commonwealth question, and mistrial was declared.
So the actual specific acts of the crime hadn't been gotten into yet?
I believe that it was, and I don't want to give you the wrong information, but they might have touched on the first two, but it wasn't inconsistent with what she testified to at the second trial. So there was nothing within the victim impact statement that was divulged during the first trial.
Do we know if the police reports described a single or multiple punches on February 5th?
There was no mention ever during the trial or the police reports that there was multiple punches on February 5th.
I'm not asking if there was any discussion at trial. I'm asking what the police report said. Do you know what it said?
Standing here right now, I cannot be confident to say that. My argument would be that the defense attorney would have used that had he had.
Well, exactly. That's my point. My point is if that was not if it's in there and it wasn't valuable enough for the attorney to use it despite knowing it from the police. I'm just trying to figure out what this judge's statement about it didn't add anything substantial to what they already knew, whether that is clear error or whether the judge was aware of other places where she had been inconsistent in this same way. The lawyer didn't think they were useful enough to impeach her with them.
For my review of the case, it is my memory that it was never mentioned in the police report. Okay. I also think that the Commonwealth would have aptly pointed that out to you had there been any sort of information in the police report that was consistent with the victim impact statement. Instead, the trial attorney had to rely on the absence of evidence, the absence of mentions of it, these sort of allegations of abuse and text messages or injuries and photographs, things in the medical records. And so I see that.
Ask you about the diagnosis of assault.
Thank you. So just to get to the second issue is I think this follows the line of cases where there's a difference between specific facts leading to treatment and helping the doctor figure out what's wrong with somebody and why their injuries occurred, and conclusory allegations that.
Didn't you have a motion in limine to redact these files?
He didn't have them specifically for assault and.
Meaning the lawyer messed up and did not ask to redact assault as a diagnosis or things about boyfriend that might have been identifying of the defendant, even though presumably if this is error, they could have been redacted.
Correct. And I think that regardless of the standard, whether we're arguing it was a judge error or a defense attorney error, the standard is the same, and I think that we meet that, the substantial miscarriage of justice standard here.
You just threw something in there that threw me. The judge's error? How did the judge make an error on that?
Because evidence is the omission of evidence is always in the province of the judge.
So if both sides agree to a piece of evidence being admitted into trial, the trial judge is supposed to go through, I think it was 52 pages, line by line, if both sides agree to find something that might be inadmissible if it's not pointed out to him or her?
Well, I think once it was admitted into evidence, he could have struck it. And regardless of whose fault this is, I think here it got into evidence. It was two different exhibits that.
Well, doesn't it make a difference whether we're looking at a potential error by the judge versus an error by the lawyer? Doesn't that make a difference for our standard?
Not under Livingston. So in that case, whether it was the judge on trial or the trial attorneys, the standard is essentially the same. It's a substantial risk of a miscarriage of justice.
Okay.
And I see that I'm out of time.
Time has expired, but if there are further questions, I see none. Thank you very much. Very helpful argument.
Thank you, Your Honors.
We will hear now from Attorney McLean.
Good morning, Your Honor. May it please the Court. Ian McLean on behalf of the Commonwealth, and along with me at council table is Brianna Arsenault, who was the trial prosecutor in the case. She's since left the Suffolk County District Attorney's Office for Essex, but she came back here to be here today. Also, just that you know, the victim does intend to be listening to the audio once it is posted, but she's not here today out of concerns that the defendant might have shown up himself. So beginning with the first issue, Your Honor, there was no abuse of discretion here. As you pointed out, Justice D'Angelo, Judge Machera presided over the trial, so he's due extra deference in his evaluation of the significance or impact of this evidence that was not disclosed. And as was pointed out here, he basically, in his own vernacular, his own way of saying, said there was no prejudice here because there was no new information. There was nothing of any value in the victim impact statement that was not produced.
Let me ask you about that. Maybe no value, but there's certainly, would you agree with the defense that there was some things in that statement that, number one, the victim did not testify to a trial, and number two, were not in the police report? Do you agree that there were some inconsistencies?
I wouldn't use the word inconsistencies. I think there's one single inconsistency which Justice Rubin pointed out, the difference between repeatedly or a single blow. I think that's, from my perspective, from the Commonwealth's perspective, that's the only inconsistency, and we can address the significance of that in a moment. The other things that I see are just a different way of wording the same thing, not an inconsistency at all. And I think part of that stems from the difference between the purpose in a victim impact statement and the purpose of trial testimony.
But it might still be exculpatory in some other ways. That is, you can imagine a good cross-examiner asking the victim, so he pointed a gun at you, that must have been terrifying. Oh, yes. But in your victim impact statement, all you mention is his threat to kill himself. You know what I mean? You know, obviously, so, right? So you're saying that now, but this terrible aspect of this, you didn't even bother to put in. You know, I mean, you can imagine using this for a little more than just the February 5th one punch, two punch, whether they're literally inconsistent or not, just because there are things that are omitted.
Sure, Your Honor. And so what you're talking about is the standard cross-examination technique that you see people use. You were interviewed by law enforcement and you didn't tell them this
before, whatever, right? So I mean, I don't, maybe there's a debate. It seems like it should have been turned over.
Yes, Your Honor. It should have been, if for
so
no other
now
reason.
let's get to the prejudice question.
Sure. If for no other reason than Rule 14, it should have been turned over. And then the separate question of whether it actually contains exculpatory material and is therefore a Brady issue. Okay. Now, as to the absence of details and that standard cross-examination tactic you would see is along the lines of you were interviewed by law enforcement and you didn't tell them detail 1, 2, 3. Right? That's a standard cross-examination tactic, really not applicable here because the purpose of a victim impact statement is not the same as the purpose of a statement you make to a law enforcement officer during the investigatory stage.
I fully agree that you would have had that argument, but, right, I mean, I don't know how to assess that. I'm trying to figure out prejudice.
Sure, and respectfully, there is no prejudice here, as Judge Machera pointed out, who presided over the trial himself, so he was there for the entire direct and cross.
Agree with his statement that there was nothing in here that wasn't already known to the defense counsel?
The only thing that I think there is an inconsistency that wasn't known was repeatedly versus single blow on February 5th.
Okay.
That's the only inconsistency.
What about the October 20, again, I don't, like Justice Rubin, I don't want to nitpick the statement, but the 20th statement, back, that
as additional or different details provided. The crux of the October 20 was, the victim impact statement was, after slamming my head against the walls, I was screaming. He punched me one last time before he left. At trial, the testimony was, he was punching me in my face and banging my head up against the wall like he always did and punched me in my stomach. Volume 1, 144. I don't see an inconsistency
What about the bat? Again, we're nitpicking because it may go to prejudice. In her direct examination, she mentions a baseball bat. But in her witness statement, when she talks about how she's getting bruises, how he comes back to the home, she doesn't mention a bat. Isn't that an inconsistent by omission?
I don't believe it is, Your Honor, because what you have here is the victim drafting, in a state of being upset, drafting by herself without the assistance of a skilled lawyer, what it was that she's remembering right now and how that impacted her, how that made her feel. And if you look at the way that she began it, she talked about, which eventually resulted in 8 months of physical violence with continuous psychological and emotional trauma. So she's thinking about the entirety of the relationship, not the specific details of every individual encounter.
Given the acquittals, or acquittal, in this case, suggesting that the jurors did not believe everything she said, or that her testimony was sufficient by itself to get the Commonwealth's case across the beyond a reasonable doubt line. Doesn't that suggest that undermining her testimony in these ways might have been valuable to defense counsel?
Respectfully, no, Your Honor. If we're back to talking about the single versus repeated, think about the rest of that incident in context. That's the incident where, in addition to the blows he delivered to her, he issued 2 death threats to her 2 sons. The first, that he was going to send her first son in a body bag, and the second, that she was going to...
And would that have come before the jury?
Yes, and that would have overpowered the significance of it.
And what exactly would have come before the jury if the defense counsel had used this to cross-examine? Do you have any thoughts on that?
Yes, Your Honor. There are several ways that there's legitimate argument that the entirety of the statement would have come in as a version of verbal completeness. Also, in order to place a prior consistent into context, some of the surrounding aspects of each individual statement would have come in.
Wait, why would it have been a prior consistent statement? All of this was after the cross-examiner suggested a motive to fabricate. He suggested the motive to fabricate happened immediately after the incident, so anything thereafter, any statement would have been a prior consistent statement.
Correct, Your Honor, and that's not what I'm meaning to argue, and I apologize if it was construed that way. What I'm meaning to argue is it's a dovetail to verbal completeness. You can't put in a portion of the statement. You have to put in enough to place that little excerpt into context. So at least the surrounding portions around each individual component that was crossed would have come in to context, if not the entirety of the statement itself. And certainly from reading it, that's going to be even more damaging to the defendant.
Do you think could the prosecutor have gone along a line of questioning the statement you were asked about? Was that your victim impact statement? What was the purpose of that? Would that kind of questioning come
Yes, absolutely. And so that's how you bring out the purpose and what she was thinking about when she crafted it, and that's how you would then draw the difference or the distinction from the line of cross-examination that you would have seen about the absence of details. That here, this was not for a purpose of investigation when, like, a law enforcement officer is asking her questions, trying to draw out and elicit all of the facts necessary. Or, as you saw during trial, during an 80-something page direct and a 30-something page redirect, an experienced prosecutor focusing in on each individual incident and drawing out all of the necessary details to meet the elements of the offense. The victim impact statement was drafted by a layperson who is recounting something that was very upsetting and traumatic to her, and you would expect that layperson to not include every specific detail that a skilled investigator during an investigation or a skilled prosecutor would pull out while they were on the witness stand.
Do you think a normal fallible lawyer would request redaction of diagnosis:"assault" in the medical records?
One could, Your Honor, but if this is...
Don't you think one should?
Not necessarily, Your Honor. It could be a strategic or tactical decision to avoid looking like you're trying to hide something. So if you look at the individual references to assault, almost every single one of them is like a triage RN in the emergency department indicating what the patient was complaining of. Here, everyone knew why she went to the hospital. She took the stand and testified.
There's a place where it says, right, diagnosis:"assault."
Yes,
there are places where she says complaining of an assault. I understand that's just recounting her, I guess, admissible hearsay about but diagnosis assault, I mean, we have cases saying that this puts the imprimatur of a medical professional on it was child molestation in the case that we have, I think, right? There's an appellate case where it says diagnosis child molestation, and that was an error. I assume diagnosis assault is, it's not really a medical diagnosis, assault, but right, that's a legal conclusion.
Correct, Your Honor. I mean, I would say it's the medical professional describing their perceived source of the injury.
Okay, so now we have, so now we have a doctor or somebody, or an RN or a nurse practitioner, whoever it is, some medical professional saying, after looking at these symptoms, I conclude this wasn't an accident, it wasn't falling down the stairs, it's not nothing, she's not making it up, my diagnosis is assault. I know the test is substantial risk. I can't see, I mean, it seems manifestly unreasonable to me not to redact that. I would think any thinking lawyer would not want a diagnosis assault before the jury.
Well, let me point you to the first Exhibit 1, and I point you specifically to page 31, so Defense Appendix page 31. There, the treating physician said, quote, "no objective signs of trauma." Now, that's a specific thing that was used by the prosecutor, or excuse me, by the defense attorney in his closing argument at Volume 3, page 58.
But I guess this goes back to redaction. Just because the defense counsel uses a portion of the medical records for his purposes doesn't mean that the entire thing comes in. page 28, which I think is what Justice Rubin was talking about, where it talks about alleged assault by her boyfriend 2 days ago. That could have been redacted, and then the rest of the medical records would still have come in under 23379.
Well, I respectfully disagree with you, Honor. On page 28, if you look at the right-hand column, it says their history provided by the patient. So the note there that is taken down is the patient describing her current course of injury. So that's a part of the medical history. So I think it comes in under the hearsay, under statutory hearsay exception itself.
Doesn't it still have to be for purposes of diagnosis and treatment? Just because the victim said it doesn't make it automatically admissible.
Correct, Your Honor. Correct, Your
So
Honor.
how is the fact of evaluation for alleged assault, how does that help a doctor in diagnosis and treatment?
Because they know it's not. They know that the source of the injury is from a blow to the person, not an internal issue.
By
at
her
all.
boyfriend. Why is by her boyfriend even remotely relevant to diagnosis and treatment?
Well, the source of the injury is not always relevant, Your Honor, but I would point this court to the McGann case. And there, just in 2020, the SJC pointed out the defendant beat him about the head, face, bit him in the arms, and came after him with a steak knife. And that all came in properly. So here it's a similar kind of situation. I mean, that's a assault and battery family household and ABDW case similar to what we're dealing with here. So a reference to who the perpetrator is can come in, but I would point out that nowhere in the medical records does it identify the boyfriend itself. I'd also point out that the victim took the stand and testified that the defendant was the attacker and that she went to the hospital. This is not a surprise to anyone. This is not a situation like Ramsey where there is an imprimatur from the hospital itself on this statement.
Well, not on page 28, but on page 41 it says diagnosis, assault. Just flat out.
Yes, Your Honor, it does, and this is the same yes, Your Honor, and this is from the same doctor who on page 31 says no objective signs of trauma, given Tylenol for pain and discharged.
Yet I was somehow able to, I mean, look, I don't know. It's not my case, but if I were a lawyer, I would redact that diagnosis.
Sure, Your Honor, and that could be a decision.
And wasn't there, I don't understand, so what was redacted? Wasn't there a motion to redact or something in limine?
Yes, Your Honor, there was, and in the second set of records, Exhibit 5 on page 51, what was redacted was presents to the emergency department complaining of having been assaulted by her boyfriend this morning, hit her head, noting her boyfriend put a gun to her head and chest. And that defendant then actually opened the door to that, and then that statement
But wait, so what was
came in.
redacted here? Do we know?
Your Honor, my understanding of what was redacted is just the second portion of that. Hit her head, noting her boyfriend put a gun to her head and chest. That's my understanding.
I see.
How about, and this is in a large portion of the records, page 48 and 49, talking about intimate partner violence. The jury gets that from the emergency room and starts reading about intimate partner violence. Why is that relevant? Why is that admissible? Why is it in there at all?
Well, I would, because the entirety of the medical records went in and the defense attorney chose not to object to them. And so I'm not sure if we're talking about this as an ineffective assistance claim or as a hearsay claim right now.
Well, substantial risk.
If we're talking about it as an ineffective assistance claim, there are legitimate tactical reasons why somebody could decide not to redact anything because they think they're ultimately not that damaging. And by redacting portions of records, you invite the jury to speculate as to what it is that they're trying to hide from
They
them.
did redact portions of the record.
He did redact one single statement of the records he sought to have redacted, and that was redacted. But the point here is that any ineffectiveness claim here is in its weakest possible form because that wasn't a claim that was raised below. There was no evidentiary hearing on it, so you're left to speculate. And here there could
I see what
be.
you're saying. You're just saying it's not manifestly unreasonable, and I assume that a tactical decision that's not manifestly unreasonable can't create a substantial risk of a miscarriage of justice? Is that part of the substantial risk calculus, whether it was tactical? I feel like.
No, Your Honor. From the Commonwealth's perspective, they're entirely separate claims here. But there was no substantial risk of a miscarriage of justice here because the things that are contained in the medical records were actually presented to the jury through the testimony of the victim, which was incredibly more powerful. So it was merely cumulative at the end of the day. And this case is categorically different from Ramsey, where you do have that official imprimatur of the hospital on the allegations.
Okay, your time has expired, but if there are further questions, no? Thank you very much. Excellent arguments by both of you. Very helpful to us.
Thank you.
The case is submitted. Our next case this morning is number 21-25, Commonwealth versus, I may mispronounce this, LAMPHIER. This is partially impounded, so I would remind counsel to adhere to the partial impoundment order. We will hear first from Attorney Bachrach.
Good morning, Your Honors. My name is Barry Bachrach, and I represent Mr. Lamphier in this case. This appeal presents several issues which focus on what I believe, and I'll focus on what I believe are the key 2 or 3. As an initial matter, this case is very similar to the case of Commonwealth v. Montero, 75 Mass App.
So Montero, there's lots of discussion about what a sane interview is about. It's a forensic interview. There's a lot of discussion about what it's about. Is there any discussion of what a sane interview is in this trial at all?
Well, yes, there is. Initially, the first complaint witness, who was Ms. Lamphier, testifies that she brought her 2 daughters to a forensic test.
Well, no, but I'm asking, is there any description of what happens there? It's called a forensic interview. And that's, by the way, after defense counsel has cross-examined the victims the day before using their statements at this same interview.
I have 2 responses here.
But the question is, was there, as in Montero, any description of what happens at a sane interview? You know, it's a transparent sheet that we're on one side, we're on the other, and then we decide there's a prosecution.
Well, I think what was close to Montero is Officer Ulak, and it comes in, testifies that this is necessary. The complaint comes to the police, and then it's at trial they're asked, Officer Ulak is asked, why was there a 7-day delay before the police report to the sane interview? And there was an objection after the defense counsel objected to the question. The judge said, I'll hear the answer, and the answer was because it was necessary to conduct. Before anything, basically implying to the jury that the sane interview is something that's necessary to conduct before you proceed. Prior to that, Ms. Lamphier has testified that she brought her children to a forensic interview, and the jury members know what forensics are, at the Children's Advocacy Center. So you put this testimony together, and there may be no in-depth description as to what occurred at the sane interview, but it's a necessary step before anything else goes further. And as the court said in Montero, the Supreme Judicial Court, citing Stuckich, the Supreme Judicial Court explained that the prohibition on the admission of complaint evidence beyond that presented by the designated first complaint witness extends to testimony concerning the fact of additional reports, even if that testimony does not contain a detailed account of the victim's allegations.
But defense counsel had cross-examined the victim, and the cross-examination included a lot of, do you remember meeting with someone named Jennifer?
Jessica.
Yes.
Jessica.
What did you say? Why did you say it? What did your mom say to you before? Whatever, all this stuff about an interview with someone named Jennifer. No, I agree, with no explanation of what the heck that might have been, but just an interview with someone named Jennifer. And now you're coming in and objecting, and this is apart from we had to wait to get the warrant issue, just to the testimony itself. Rather than describing it in asking the mother, because of course the prosecutor's entitled to ask the mother, did you tell them to lie when they went in to talk to this person, Jennifer? You agree with that? If he had said, this interview with Jennifer, did you tell them to lie before that? That's got to be an okay question, right? After the cross-examination of the victim. If you don't call it a sane interview or forensic or mention the Child Advocacy Center, if she just said, yesterday your daughter was asked about an interview with someone named Jennifer, did you tell them to lie on the, what did you tell them on the way in there? That's.
I don't disagree with Your Honor to the extent that, but I think.
So now you're saying, but the prosecutor can't use the proper name of what this was, a forensic interview with the Child Advocacy Center. I mean, that's a pretty thin slice, isn't it?
Well, but if you look at, you've got to look at the entirety, Your Honor, please. Even if the prosecutor is going to be allowed to talk about what the sane interview is, and you've already now got testimony from the police that the sane interview is a necessary aspect, and there's evidence just, this is a related but separate.
Wait, when was the police testimony? After the mother?
Right after the mother testified, Officer Ulak testified.
Okay, so when the question is asked of the mother, I understand there's an objection to the police thing. I'm trying to first figure out the mother's testimony, the question to the mother, did you go for a forensic interview at the Child Advocacy Center, whether that is objectionable or not. Assuming nothing else, at the moment it was done, if someone had said, I don't know if was it objected to? I don't think so.
Well, the way it came out was the question started to be asked, defense counsel objected, the judge said, no, I'll hear the answer, and then the rest of the question was very detailed about, did you bring the children to a forensic interview at the Child Advocacy Center? And the answer was yes. So right at that point, the prosecutors put in the question that she took the children to a forensic interview at the Child Advocacy Center, which then, if you go down to the next witness, testifies that this is necessary, and there was a week delay. It was necessary for the sane interview. And then you get the testimony.
Well, that first piece, the first piece of testimony, that's the only objection, right? The only objection is to the question, why was there, what was the reason for delay in executing the warrant?
Why was the
Objection comes in, and the officers, it's overruled, and the officer says, we had to wait for the sane interview. Now, I don't know how a juror would take that. They might just think he's saying, you know, just as a procedural step, right? Like I'm not allowed to go get the search warrant that I already want. I got to wait a week for this thing. That's just our rules at the police department. It doesn't matter if I believe what she said or didn't at the interview. That's just the procedure. If there'd been no further discussion, or do you disagree with that? Do you think that it implies?
I think the fact that Officer Ulak, or the question said it was a necessary. Yeah. It's different between, why was there a week between reporting the police and having a sane interview? The word necessary.
Well, so that needed to be performed. So there was the sane interview that needed to be performed for the children.
Needed to be performed. And then.
Well, we're lawyers, right? I don't know if the sane interview needed to be performed. Right, you get a warrant on probable cause.
Well, but the jury.
No, I understand. I'm just trying to think about what the jury isn't lawyers. So I'm trying to understand how they might have thought necessary. Now, we might think he means necessary because he didn't think he had probable cause yet. Right?
Correct.
That's what we think. And, right, that must be what he thought, I guess. I don't know why.
But this is one of those cases you have to look at it in the whole, because the next testimony that comes in is that it was not until after the sane interview was.
Immediately after. I went straight from the sane interview to the magistrate and got a warrant.
They got the warrant, which is consistent. It's not the same exact as Montero. I will admit that Montero is more egregious, but I don't believe that this case is that. If you put on a scale of egregious, here's Montero, and I think here's this case.
What was prejudicial about it? That's what I'm missing, is the next step. What was prejudicial about it? What do you think the jury got from that?
Well, the jury can think from that the same forensic, now they know that forensic interview, the same interview is a forensic interview, that the police needed to wait a week for that to be conducted.
Okay.
And immediately after that's conducted, warrants issue.
Okay.
And the jury could, that implies that this necessary sane interview had to be conducted, and the jury can believe that, they were believed at the interview because the warrants issued.
That makes some sense to me.
I'm sorry, Your Honor?
That makes some sense to me. I mean, there was no objection at that point, right? Which is why I was focusing on how would a jury understand the objected to part, because I'm trying to figure out what our standard is.
Right, I mean,
I don't love any of this. I'm not sure why, I'll ask, of course, opposing counsel. I don't understand what the relevance is for the jury of the reason for the delay in issuing the warrant. I don't understand, like, what's that got to do with anything? I mean, if the answer was, I guess, you know, there was a lightning storm and the electricity was out for a week, so we couldn't call the judge or so, you know, I guess maybe that's something. We really wanted to get a warrant right away, but we couldn't. But I don't understand what the relevance of that is.
Well, the relevance is, I think you're right. If there's a week delay and it was left at that, there's week delays. Everyone, you know, jurors, lay people are used to delays. But it was Officer Ulak's saying the delay, and it was necessary.
Can I ask you something? Somewhere in this record, I thought there was a statement that the defendant had 2 hours to hide the things from the ceiling. But it seems like he had 7 days, didn't he?
What?
It seems like he had 7 days between being alerted that this disclosure had been made to the mother and the time the police go to his house. Someone said he had 2 hours. I thought in closing maybe the prosecutor says he had 2 hours notice and he could have hidden the things from the ceiling. But didn't he actually have 7 days notice?
There was 7 days, but Your Honor, I think that is a red herring, because if you read 34 to 36 of my brief, the police scoured that house. Now, the things that was supposed to be...
Oh, I see. Your point is, unless he threw them away or something, they would have still been in the house.
If he's storing cups that had...
Whatever, there'd be some evidence.
Whatever, and if he's just storing Astroglide up there, and there was no evidence that any of the panels had been moved, there was no evidence that, and I can read it right, if you look at page 34 to 36, it's undisputed that police did a very thorough investigation, and there was no evidence that there was any new tiles or anything. And so, and if you put that with also the fact that none of the pornography or pictures were found, you know, it's credibility issues, Your Honor. The only time at trial the prosecutor made one mention of the timing, and that was in closing argument, if I recall. I didn't raise that as an issue because I thought that the way we addressed it, and if I can address, there's one disturbing issue I have in this case where the prosecutor asks the Ms. LAMPHIER, you know, did you hear your father make an admission? And she says, yes. And then to the next question, she starts back off saying, no, I didn't really hear it from, I heard it from my mother. And the counsel objects. And from that point, the record gets very confusing. The judge strikes the last sentence. Well, the last sentence he struck was, well, it wasn't my mother, it wasn't my father, I heard it from my mother. And then there's a long colloquy, about 3 pages. And so the jury is left, and if we assume the jury follows instructions, that admission that came on, that was very strong before the break, that she heard the mother say what the father said, I found very troubling, and the judge did not correct it by his curative instruction because there was, he got confused as to when, but I think that is another error, putting on top of all the other errors that just made this a very unfair trial, and that's, unless you have, Your Honor,
No, your time has expired. If there are further questions, are there?
That's okay.
Okay. Thank you very much. Very well argued case.
Your Honor.
We will hear next from, I think I have this sheet right in front of me, from Attorney Nadeau.
Thank you, Your Honor. Good morning. May it please the Court. I am Stephen Nadeau, Assistant District Attorney from the Bristol District on behalf of the Commonwealth. I'll begin by addressing Justice Rubin's question about the discrepancy between the 2-hour window and the 7-day window. The 2-hour window received the most emphasis in the prosecutor's closing argument. The 7-day, I think, wisely received less attention in the argument, but that 2-hour window reflects the time between the defendant hearing about the allegation from his daughter, your granddaughters have made these allegations, I want you to come to the police station with me right now. He says, no, I can't do that, it'll kill me, it'll kill your mother. And then he has these communications with the police where he's talking to them, he's out driving somewhere. He says he doesn't know where he is. I would suggest that opportunity for him to dispose of any potential physical or digital.
Can I take you to where your opposing counsel ended?
I'm sorry?
Can I take you to where your opposing counsel ended his argument, which is on this hearsay statement?
Sure.
In my view, that's the most important evidence in the whole case. You have child witnesses, you have no forensic evidence. The witnesses also describe things like seeing pornography on phones or whatever. It is, I think, I don't know enough about this, but there was certainly no evidence that these looked like hard drives that have been wiped or, whatever the complicated procedures one has to do to avoid forensic discovery of pornography that used to be on a computer, which I gather is something that experts can find, even though it's been deleted unless you do something quite complex. So that draws into question some credibility there. No evidence of this tiles being moved or of any spills or anything that you might expect if over a long period of time liquids were put above a ceiling in one way or another. But then she says, my dad said to my mom, I didn't want you to find out this way. Oh, that's a confession. That's game over. That's the, in my view, as I read this, that's the most important piece of evidence in the whole case. And there's no error in the way it comes in because, of course, she initially says that she heard her father say it, which would be a party admission. And then she sort of corrects herself, says, look, I didn't actually hear it. My mom told me, okay, the jury goes away, lengthy sidebar, at which at the end of the day the judge correctly concludes that's inadmissible hearsay. But the curative instruction, I'm sure it was based in good faith on people's memories, that was the last question that was asked. It wasn't. There was a further question and a partial answer. And so when he instructs, disregard that last question and partial answer, if the jurors could remember it better, they would be like, okay, the last question, partial answer, which is after the statement that he said this. So the curative instruction is not curative. Now what do we do?
Well, first, I disagree that the statement was not cured. I think it was covered.
How can it be covered by an instruction that, when you look, clearly doesn't cover it?
I think that although the transcript kind of presents everything happening, in sequence one after the other, I think in reality, it's more, if not exactly simultaneously.
I'm not sure. It seems like you're good. I mean, it's obviously not simultaneous. You can't say two things at once. It's in that order. Might have been shortly thereafter, but it's in that order.
Sure, but I think that the parties clearly understood, the judge, defense counsel asked for the remedy.
There was no objection to the curative instruction, I agree.
And then there was the break for the voir dire. He comes back and again says something about striking, disregarding the last statement, but he also says disregard anything that was said with regards to that.
Right, I mean, but counsel, like defense counsel can't say, no, Judge, what I want you to say is, ignore the part where he confessed. Like,
yeah, obviously the defense counsel doesn't want him to repeat you may have heard that he said.
Think that.
Like, oh, did I hear that? I was looking at my newspaper.
Can I ask it in a different way? The prosecutor asks the question, like the prosecutor knows there wasn't an admission.
Right.
Is there discovery that the defendant admitted?
Yes, that came in as one of the statements, but then I think they understood that as part of that phone call on speakerphone, where the defendant also said, this will kill me, this will kill your mother because no one's there. I don't think the prosecutor at the time realized that that was from a separate conversation. So I think...
yeah, I'm not saying the prosecutor deliberately elicited it. I'm just saying, based on what she says next, which is, oh, I didn't actually hear it from him. That, right, maybe it's mistrial stuff, right? But whatever, the defense counsel seeks a curative instruction, appropriately, I guess. And I think, I at least agree that's inadmissible hearsay, because there's no exception for the mother that I can think of,
yes.
right?
I agree that it was inadmissible hearsay, appropriately excluded and stricken. And I think, again, the parties, everyone understood and the judge didn't obviously want to repeat it himself in his curative instruction, but the parties at the time understood that what the instruction was about. The jury likely understood that too, and again, kind of following up after the break with disregard everything with regards to that is sort of broader than just the very last thing they might have said, but a jury is not going to be parsing it that closely, and the fact that the counsel didn't say, even if he didn't want to repeat the hearsay statement, I would like a more clear instruction, the specific statement. The fact he didn't do that both deprived the court of an opportunity to clarify, and as well deprives us now of a record of exactly what everyone thought was going on. And so his acquiescence in the remedy suggests that it was effective at the time. I also disagree that it was the most important evidence in the case, although certainly a damning admission. I think it is largely and essentially cumulative of the statements that did properly come in. This will kill me, this will kill your mother, in response to an allegation that you have sexually abused.
Rather than a denial, you mean?
Right.
Well, it's not quite like I say, to me, it's the single strongest piece of evidence in the whole case, that sentence.
Again, I disagree. I would suggest that the testimony of the two...
You have to disagree.
Again.
But I don't think the others are... I understand, wouldn't you say, I didn't do this, are you trying to kill me, are you trying to kill your mother, right? Or, whatever, but I don't know if it's cumulative.
And and again, it's not a specific, admission either. It's not, I didn't want you to find out that I did X, Y, and Z to child A, child B. It's again kind of phrasing this like, oh, I didn't want you to find out this way, this will kill me.
It's all so bizarre.
But I would suggest that the strongest evidence is the testimony of the two victims in this case, two very young children at the time this happened, and certainly child A at the time of testimony is still, I think, 10 years old.
Can I ask you about that? This case, to me, comes down to the credibility of the children. And the Commonwealth called Officer Faria, I believe was the name,
That was the defense witness.
defense witness, to cross-examine about inconsistent statements. On cross by the prosecutor, defense counsel suggests that the officer was vouching for the credibility. And I'm trying to figure out from your brief how it wasn't that. You talk about it being a prior consistent statement, which we could go down that road, but I don't think that's a good argument because there was no limiting instruction, number one, regarding a prior consistent statement. Number two, it was clearly after the motive to fabricate that defense counsel was suggesting. So how wasn't that vouching for the credibility of the children?
Well, for a couple of reasons, and first, I don't necessarily think it came after the motive to fabricate because there's suggestions from the cross-examination and the defense theory that even at the meetings with prosecutors that they may have coached the children with what to say. So kind of going into the consistencies from that 2017 meeting with the prosecutors to how their statements in 2014 were consistent, I think was certainly appropriate. Pardon me.
But there was no, after you're finishing with your word, but there was no suggestion of a limiting instruction, so it came in for full value. So tell me why it's not vouching.
Correct, but it was a single question and answer in response. Wasn't the vast majority of what they said consistent. That is, may imply a certain value judgment, but is ultimately more of a objective, most of it was the same, right? Not, you believed most of it, didn't you? That's a separate, obviously, improper.
So because the question didn't use the word believed, it doesn't go to credibility? The majority was the same or was consistent. Isn't that a jury function to decide whether the statements are consistent with one another, not an officer's opinion?
Again, I don't know if there's evidence that's opinion. I think that is a objective description that the majority of the statements were the same. Particularly here, I don't think there was an issue because the substance of those statements had been elicited so thoroughly by the defendant. So that you're already talking about the various different statements in 2014, 2017, and what the testimony is, and how those may have matched up or not, and had there been a real issue with that description of it as being majority consistent, the defendant had the opportunity to follow up on redirect, in this case, to explore why that would have been an inaccurate statement. But again, we don't have that here. Certainly, defense counsel's attention was on this issue because it was the crux of the defense.
What's the purpose of asking the officer why did you have to wait to have the forensic interview before you got the search warrant? Like, was there a reason that was necessary to respond to something that the defendant had brought up? Or?
That, again, to explain the absence of physical evidence, digital evidence that the defendant had broached in opening statement. That you're not going to find any of this pornography or these photographs or this astroglide or any of these other things. So, again,
So you're to establish that the defendant had an opportunity to get rid of the evidence, or?
Yes, and that's how it's used, again, very briefly in the closing argument, just to say he had this time. It was not to say.
Well, that week isn't used at all, right? It's only the 2 hours before he goes to the police station that's used. Am I wrong?
Well, that's the primary focus.
Does the prosecutor in closing refer to that week?
I think there's just a one-sentence reference to the week. Again, the argument primarily focuses.
Does the prosecutor talk about the pornography in the closing at all?
I don't think specifically, but just in terms of being able to get rid of any evidence that might have been there. That it may have been implicit with the condoms, the astroglide, but I don't think specifically says and erased his computer. But I think, that's the thrust of the argument there. But overall, The victim's mother in this case represented the very center of the defense theory, what she may or may not have told her children to say, and how their statements may or may not have changed over time as the case proceeds to trial. To the extent that was, again, the centerpiece of the defense theory, the Commonwealth was entitled to respond within appropriate limits. I think the responses here, and again, and occasionally approaching certain boundaries, but all within those limits on the particular facts of this case. Again, we argue that even if there were errors, in the one that we acknowledge, it was cured at the time, and any errors such as they were not prejudicial. If there are no other questions, I would rest simply on the brief.
Thank you.
Thank you very much. Very good arguments by both sides. Very helpful to us. The case is submitted. Our next matter is number 21-1060, Commonwealth versus Turner. Once again, this is a partially impounded case, so if counsel can be sure to adhere to the impoundment order. And we will hear first from Attorney Stiles.
Thank you, Justice Rubin, and good morning, members of the panel. Attorney Ethan Stiles on behalf of Benjamin Turner. And we're here today on appeal because of an unusual circumstance which occurred at the end of his initial civil commitment trial, that the jury made a post-verdict statement explaining some of the reasons why it decided that he was a sexually dangerous person. Now, the note is...
About that first. What do you believe it was error for the judge to allow any type of post-verdict statement at all?
Well, I would submit, Justice D'Angelo, that this is a situation where the judge may not have been fully in control of the he was not in a position to allow or disallow them to do anything, because once they have made their verdict, they can say what they like.
Well, but wasn't there before the verdict, wasn't there something suggesting that they wanted to give a statement, and he conferred with counsel and basically said, I'm not going to allow them to do it during the verdict, but I'll allow them to talk afterwards? Couldn't the judge have just responded to the question, no, you make your verdict and that is all?
Yes, that was what did occur. The jurors did send the note, and the parties did have that discussion, and that's what the judge decided. But after that, while they're still in the court, they're still in the jury room, it was immediately after they had made their verdict, Mr. Turner was sent on his way, that they asked the judge and the attorneys that they'd like to have something to say, and they were all there, and they made this collective statement. So I think we have it here. So we need to consider its implications. And its implications.
So isn't there a rule that you cannot impeach a verdict with discussions of the internal deliberations unless it has to do with an external factor?
I think that rule, that is the general purpose in which we consider these types of claims, when there is an extraneous influence. But there's also language in one case, I think it was Wyatt, where they can, if the verdict was a product of bias, misapprehension, or prejudice. Now, I'm not arguing that the jury misapprehended the law.
Racial prejudice. There's a small exception for racial prejudice during the deliberations.
Yes, that is correct. And we're not claiming extraneous influence or racial prejudice here. We're going to the more unusual situation where...
You're saying you're going to go inside the deliberations and find out what the jury actually talked about, and then say they did it wrong, so we have to get rid of the verdict.
See, we're in a unique position here, Justice Massey, where we didn't have to go to them. They came to us, so to speak, because they volunteered the statement. No one asked them, how did you guys deliberate? They said, this is what we considered, this is what we found. And I would suggest that what we have here suggests evidence that they essentially disregarded the judge's instruction on the burden of proof. And that is a rare situation, no doubt, but I think that is one of the few times...
Counsel, let me follow up on Justice Massing. let's give a hypothetical. After the verdict, a juror writes a note to the judge, they've been sent on the way, and says, we thought the burden was on the defendant. That's what we discussed during our deliberations. Is that a proper thing for a judge to question jurors about? Doesn't that go directly to the deliberative process?
Well, it does go to the deliberative process, but when one juror says it, I think that's not enough. I mean, now, when the cases, that talk about, cases like Fiddler, for example, where they talk about one juror submits an affidavit that says what went on in the jury room, the courts, say the judge doesn't have to consider that because, because they don't want to turn a jury trial into a trial of the jurors.
So when does a court like us or the SJC decide to get into it? Is it 4 jurors, 5 jurors, 6 jurors? What's the line, and how are we supposed to find that out?
Well, in this case, we have all 12. There was no indication that any juror was not present or said, I disagree with the statement, I have my own reasons. So we have all 12. So I think we are in the rare situation where we can find that the jurors may have misapprehended or disregarded the law.
Well, look, it seems clear to me, well, we can certainly assume you're right, but it does seem clear to me that if the jurors sent a note after the verdict that said, Your Honor, this was such a tough case, but then we're really lucky, we just want the defendant to know, we decided it by tossing a coin. We had no idea how to figure it out, and so we just tossed a coin. We all agreed that would be the best way to figure out if he was guilty or innocent, and we just want him to know, it's not that we really concluded he was guilty, but, tails is tails, and so that's the game is over. I presume that a court could take some action in the face of a statement like that by the jurors that they had done something really wrong in the process, even if it wasn't extraneous. The problem I have is I don't think that you've made your case that this note says or amounts to we shifted the burden of proof. Because it may be that the prosecution's case persuaded them that he hadn't learned his lesson, or whatever the phrase is that was used, that he hadn't learned to control himself. That's their burden. You see what I mean? To me, this just doesn't. How do we know whether what they mean is we shifted the burden, or this is what was proven by the Commonwealth?
Well, I think what we have to do, when we look at the note, it's 3 sentences, and as the Commonwealth points out, and I agree, that the 3 sentences parallel the 3 elements which the Commonwealth had to prove: prior conviction, dangerousness, and likelihood of reoffense. So now, the note starts out, the first sentence is innocuous, but it becomes pear-shaped as further that you read, and I think the combination of the second and the third sentences come to a theme of that the jurors expect change or reform or treatment, that they expect Mr. Turner to do these things, that he hadn't, because the evidence was pretty clear that his treatment was preliminary at that point, that they believed that he had not shown to their satisfaction that he was not sexually dangerous.
But it doesn't say that. It says, we agree. Well, all right, so we agree that he served his time. Okay, fine. It would be hard to disagree with that. That's what this proceeding is. We agree that during his incarceration, Mr. Turner has not learned to adequately manage his antisocial personality disorder. Isn't that what the Commonwealth, one way of saying what the Commonwealth has to show? So how do we know whether they're saying, we agree that the Commonwealth has shown that during his incarceration he has not learned, versus he was supposed to show us that he had learned and he hasn't shown us? I just don't understand why we're supposed to take this as given that they were instructed properly on the burden of proof and so on.
Yes. Well, I think part of the troubling part is that it focuses on what Mr. Turner must do, what Mr. Turner must show.
It doesn't say that he has to show. It says, we agree that during his incarceration he has not learned. It doesn't say he has not shown that he has learned. It doesn't say the Commonwealth has proven that he has not learned. It doesn't say either.
Yes, and then they go on to talk about treatment, and the implication is that through treatment, he will learn how to control himself, as opposed, for example, to the fact that he
He's
may...
been given an opportunity and time to learn the skills to manage his personality disorder, as well as the strategies necessary to make him sexually safe in society. But that is why, at least in theory, why people are sent to the treatment center. I don't know whether it's ever been effective, but that's the idea.
Yes, and, but essentially, it still puts the onus on him to do things, to show things, and essentially, at some point, it starts to implicate the burden and who has the burden, because...
Okay, so they don't know that there's a redetermination hearing or whatever, right? But in the I mean, if you said to them, you know, we're going to do this again in some number of years, they'd say, well, we hope by that time the Commonwealth will not be able to show, as they did to us, that he hasn't learned to control his personality disorder.
Now,
I don't know, I mean, I'm not sure what to do with this. We have to figure out what this means, and I just don't think it clearly says we shifted the burden of proof and he hasn't shown. Just as we agree that.
You want us to infer something from these words, and the Commonwealth is going to get up there and say it infers the exact opposite. So what are we supposed to do with that, I guess, I'm following up on Justice Rubin, is we're trying to make sense of what this note means, and you want us to understand it one way, and the Commonwealth wants us to understand it another way. Is that enough for you to carry your burden on this appeal?
well, I mean, obviously, in this particular case, you know, the Commonwealth does have the burden of proof. It never shifts, and the defendant doesn't have to put on any evidence to suggest that he is not sexually dangerous. But this kind of language suggests, well, maybe you do.
Can I ask you a question? In the case of extraneous influence, do we allow defense counsel to hire investigators to talk to jurors or to go and talk to jurors, or do we require the court to call them in and do a voir dire after the fact when things emerge? What is the proper procedure for sorting out whether extraneous influence might have... I had a case a few years ago where there were protesters outside the courthouse. It turned out afterwards, and the judge hadn't known that the jurors had to walk through sort of a phalanx of protesters. And then when the judge did find that out, she took some steps, I don't remember, post-verdict steps, to ensure that it, you know, that it hadn't... In fact, do you know what the procedure is in such a case?
Yes, Justice Rubin, and let me talk a little bit about it, because it's changed in the past 10 years, whereas until relatively recently, the idea was that if there's post-verdict issue, counsel can investigate it. They can receive information from a juror if the juror wishes to volunteer it, but counsel can't investigate it, and whether that rises to a level of extraneous influence or not tends to rest on the abuse of discretion standard with the judge, if counsel can present something to the judge. Now, more recently, the standards change, where defense counsel can reach out to jurors, but he has to do so when he can't be aggressive about it, at the very least. He can't say, well, talking about the juror deliberations, it's more like, hey, I'm attorney so-and-so, I represent the defendant, I think there may have been an issue, is there anything you'd like to tell me? That's the sort of approach that I think you can take under the current rules. But the older cases which talk about extraneous influence, I think most of them are, talk about the older rules where it's harder to develop.
There was no motion for a new trial here, right? This is direct appeal?
This is direct appeal.
So it might still be possible, for example, to bring a motion for a new trial and to see if you can get elucidation of this statement to the extent it's permissible under the law and the rules of ethics, to see it, to figure out what this, in my view, at least ambiguous statement means, and, maybe the burden was shifted. I mean, that's not really how I read this, but I understand what you're saying. Maybe it is. That's still an avenue that would be available. I know obviously you don't want us to affirm the judgment, but if we did, that would be an avenue available to your client, would it not?
It could be, although if he has an intervening Section 9 petition, that may prevent that kind of situation, but he has not. So theoretically, yes, Justice Rubin, it would be available to him.
So I have to, full disclosure, I had a case like this a while ago too. I published it. It's called Commonwealth versus D. Benedetto, 94 Mass App 682. And after the deliberations, the judge went into the jury room, and the jury suggested that they weren't unanimous. And we said you can't you can't impeach a verdict with information like that. If we start doing that, I say in the opinion, we might start to ask who, if they understood the burden of proof.
Yes, Mr. Passing.
So neither one of you found that case, which is kind of directly on point. We'd have to overrule Di Benedetto in order to find in your favor, and I probably wouldn't be inclined to.
Which goes along with the hypothetical I asked right at the beginning, is how far do we go questioning jurors about the deliberative process? That's what you're...
Well, we can only go as far, I think, as they let us, because we cannot force them unless the issue does involve extraneous influence or racial bias. We have no case law that says we can enforce them. But what we do have, we can work with what we do have, and what we do have here is statements that suggest that he has. That he may have some obligation to change or reform himself or to improve himself, and then show us. I mean, it can be difficult when you're talking about treatment or lack thereof, because that involves an affirmative obligation of a sexually dangerous person versus a more passive obligation, which is to merely age out of his antisocial behavior. So, as my time is expiring, I would just leave the court with the observation that this is his initial trial, and if we don't get it right this time, he may not have the same advantages and opportunities to get it right at a release trial. And with that, I would rest on my brief.
Thank you very much. Interesting case and very good argument. We will hear next from Attorney Hansen.
Good morning, Your Honors. Arne Hansen for the Commonwealth. There was absolutely no evidence of burden shifting in this case, in this record. And the burden shifting generally comes up in the sense of a prosecutor making a misstatement or instructions being incorrect or a judge making a misstatement. There's no evidence that the prosecutor made any improper statements during either closing arguments or opening arguments. They did not comment on the fact that the defendant didn't testify. They didn't comment on the defendant's ability to refute the Commonwealth's evidence, or they didn't comment on any witnesses that the defendant may or may not have called. With respect to any improper statements by the judge repeatedly advised the jury in closing as well as in opening statements and during the jury charge that the burden was on the Commonwealth, and he explicitly stated that the defendant, Mr. Turner, did not have to prove anything.
So I haven't looked at De Benedetto because it was not, I'm looking for it now, because it was not cited to us. If this note said, and was signed by all 12 jurors, "Dear defendant, we have found that you have not met your burden of showing that you learned something," could the court do something about it?
I don't believe so, Your Honor. That would go to the reasoning of their verdict. I would point the court to Commonwealth v. Fidler, which I did cite in my brief. That's 377 Mass 192. Fidler explicitly states that evidence concerning the subjective mental processes of the jurors, such as their decision, the reasons for their decision, are inadmissible to impeach that verdict.
But if they wrote in a note, "Dear defendant, close case, but given your race, we decided guilty was the best way to go."
That is correct. Then you would be able to impeach that verdict because there's evidence that it was motivated by racial bias. And that goes to McCown, which I believe that I cited in my brief as well. So, but for extraneous...
Well, but the racial bias wasn't extraneous.
Racial bias is another exemption that exists outside of extraneous. So extraneous would be third-party
Sure. I get that. There's nothing else the jurors can do or say. We tossed a coin. We drew lots. Most of us were asleep during the trial, so we're not really sure what it was about, so we tossed a coin.
We thought that the Commonwealth is overcharging defendants, so we're going to acquit everybody that we ever, any juror.
And to appeal an acquittal.
Right, but yes, but you see, you can only be able to inquire on guilties, but not on not guilties.
Huh.
Well, that's certainly an interesting hypothetical. I don't know if tossing a coin would go to extraneous or third-party information. It might, you could potentially argue that by tossing a coin, they're considering information that is outside of the scope of the evidence because it's not within the evidence.
Do you think counsel for the defendant in this situation, just by asking us to, I would suggest, glean what went on during the deliberations, is asking for another exception to that rule? By trying to infer that the burden of proof was shifted here?
Potentially, but I just don't see any evidence of it. All I see is evidence that the jury understood the charge. In her opening statements, the prosecutor stated, I have 3 questions, these are the elements. The first element being, was he a convicted sex offender? That was never in dispute. The second element being, does he suffer from a mental abnormality or personality disorder? The Commonwealth's theory at trial was personality disorder because there's no evidence of a mental abnormality. And then the Commonwealth presented substantial evidence from their experts that he did have a personality disorder and that he was diagnosed with a personality disorder. He exhibited antisocial behaviors while incarcerated. He refused to go into treatment, which exacerbated his risk of recidivism. So there's substantial evidence there. And then the third element being that was he likely to re-engage in sexually offensive behavior, which again goes to the evidence that was presented at the trial. So I would suggest that the note demonstrates that they understood what was before them and applied the evidence, the Commonwealth's evidence, and they credited the Commonwealth's evidence, and then they gave a justification as to the verdict. And because this is a justification as to the verdict, we can't consider it. It cannot be used to impeach. Does the court have any other questions?
I see none. Thank you very much.
Thank you, Your Honors.
In case it is submitted. Before taking our mid-morning break, we're going to hear one more. This is number 22-202, DCF versus Mother and Another. I will remind the attorneys that this is an impounded case and pseudonyms or descriptions should be used for the parties rather than their names. I gather each side will be dividing its time with father going first and then mother each for 7.5 minutes, and then DCF 8 minutes and the children 7 minutes. Is that consistent with your understandings? Very good. So given that, we will hear first from Attorney Hoffman on behalf of father.
May it please the court, good morning. My name is Andrew Hoffman. I represent the appellant father in this case. And on his behalf this morning, I'm asking that this court vacate the finding of parental unfitness and the order of terminating his parental rights that followed from that. Just as a quick point of clarification, there's 5 subject children in this case. Ironically, the youngest shares my client's name. He's a junior. That is the only one that my client was not adjudicated as the father of. So my client's appeal pertains only to the 4 oldest and not to the youngest who shares his name. So just want to be clear on that. I raised 2 issues on appeal. The first is sufficiency of the evidence, and the second is what I'll call the currency of the evidence. Starting with the sufficiency of the evidence, the court relied very heavily on 2 main factors, which are substance abuse and domestic violence. With regard to substance abuse, the trial court found that my client had a significant history of substance abuse and used what I referred to as this generalization of this history several times in its conclusions of law, justifying its finding of unfitness and termination of parental rights. Upon close inspection of the evidentiary record, however, it's apparent that there's insufficient evidence of this substance abuse history. And I would point to DCF's own analysis in its brief. At page 19, there's a scant one paragraph that it devoted in its brief to the evidence of the father's substance abuse history. He was found to have drugs on him in 2010, some 10 years prior to the trial. It's unclear, but I think presumably that instance was for personal use. By his own admission, he turned to drugs in 2020 after he was evicted and before he had gone into treatment. He admitted that to DCF himself in December of 2020. His last drug use was in or about December 2019.
Is that in the record?
Which part?
That was his last drug use?
It's in the record, Your Honor. It's by his admission only, and that's one of the places that DCF and Child's Counsel take the father to task.
Well, you say in your brief that he's had 20 months of sobriety, but we have no evidence of that.
So that's correct. The 20 months of sobriety is measured
And we're
by...
allowed to draw an inference against him from his failure to show up, that he had nothing to rebut the DCF presentation with.
So a couple points I would make in response, Your Honor. And I'm not sure if this is going outside the record, but I'll use the expression the difficulty in proving a negative. In other words, he's being asked to prove that he did not do something.
All day long, drug addicts have to prove in court that they didn't do something by putting in urine screens and a wide range of their ways of demonstrating sobriety, sure.
Right, I was going to say the most objective manner in these cases typically is substance abuse screens, and you're correct.
But he didn't take any or submit any?
He did not submit any. Whether he took any is not in the record, but certainly it's in the record that he did not submit any. And as to Your Honor's point about the adverse inference drawn from his failure to appear, he did not appear for a single day.
It hasn't been there since 2018.
He did not appear for a single day.
How was he fit? How was he currently fit at the time? He had outstanding warrants. If he showed up in court, he'd be arrested.
Right.
He'd be incarcerated in all likelihood. And how is he supposed to care for children? How could he be currently fit?
So it's not in the record why he did not show up for court.
Well, he didn't show up because he has outstanding warrants.
I think that's a reasonable inference. It's not clear what...
Or he doesn't care about his children. He also turned down having custody of them in favor of foster care when he was told all he had to do to have full custody of them was separate from mother.
Right. I would respond that it's a much more reasonable inference that he failed to show for trial due to the outstanding warrants than...
Neither one's too great.
I will not argue with that, Your Honor, but I will say that I think there's ample evidence in the record that he does care about his children. I do think that
I didn't say he didn't care about his children. I said I don't see how the court was supposed to conclude he was currently fit.
Right. So there's a lot there to unpack. Let me try and respond to some of that. So first of all, it is certainly within the trial court's discretion to draw an adverse inference when somebody doesn't show up for trial. That said, not cited in my brief, but I will cite here is the case Custody of Two Minors, which is at 396 Mass.
Have you ever spoken with him?
Please?
Have you ever spoken with your client?
My client, of course, yes, I have.
Well, you say of course, I don't know.
I'm sorry, I shouldn't say that. Yes, I have.
Recently?
Yes.
Okay.
Yes. So Custody of Minors, 396 Mass. 610, 1986. And I cite that for the proposition that the adverse inference drawn from failure of a party to testify is not sufficient by itself to meet an opponent's burden of proof. And what I mean by that is the adverse inference is not the entree. It's not the main course. It is to supplement, to buttress evidence that's already there in the record. And so if the main basis for these findings is that he didn't show up to address it.
He was convicted of assaulting one of the children. He was incarcerated during a large period of this time. He has a drug problem and you combine that with the inference. He didn't take the children when he was offered them.
Right.
And then, right, I mean, it's on top of other things.
So with regard to the assault of the child, I will note a couple things, Your Honor. Yes, he was convicted, but number one, DCF in its own 51B
yes, I
investigation.
agree, suggesting that perhaps we ought to figure out who works at DCF. He was convicted beyond a reasonable doubt by a jury of his peers of having assaulted the child. The fact that they found the allegation unsupported is mystifying to me, but I don't think it trumps the jury finding.
Well, I would say it's not mystifying if you read the 51B. They talked to the children, they got to the bottom of exactly what happened.
He was convicted beyond a reasonable doubt of that incident.
Right. And
criminally.
Right. And the second point I would raise is that a mere 2 months later, when the children were removed on an emergency basis, DCF did go to him and try to place the children.
Maybe I'll ask counsel for DCF who works over there and what they're up to.
Well, I mean, I cite it, and I'm glad that Your Honor picked up on that, because it certainly is indicative of what DCF viewed as his level of fitness, and that's part of my argument is the currency of fitness, as I argued in my brief. He started out, that was his baseline where he started, not somebody with, as often happens in these cases, you come in with a long history on fitness. DCF clearly viewed him as appropriate at that time of the removal in the fall, late summer, early fall of 2018. Now, he did not take them up on that offer at that time. He chose to try and work things out with the mother. One could argue whether, in hindsight, whether that was a good decision, but that was certainly DCF's mindset at the time. He did, unfortunately, hit a rough patch for quite some time, fell out of contact, fell out of compliance with DCF, became homeless, used drugs, et cetera, et cetera. But again, to go back to where he stood at the time of trial, by his own statements, and again, there's no evidence to support this, he'd been sober 20 months, he was employed, he was completely separated from the mother at that time, had his own residence, it was in a new relationship, and by those measures was doing well.
I'm sorry, and I know your red light.
I just saw the red light come on, I'm sorry, go ahead.
My math may be wrong here. You keep saying 20 months.
Yes.
His last reported use of drugs was December 2020, right?
So,
Self-reported.
Yeah, I actually disagree with that. That's how DCF characterized it in its brief. As my reading of it is that he reported...
The judge found that, too.
Well, no, my reading was that he reported to DCF in December 2020. That was the time he spoke to them, but he was not telling them at that time that that's when he last used drugs. His report was the last time he used drugs in December 2019, so that's where I got the 20 months from.
Okay.
So.
All right, your time has expired unless there are further questions. You're doing a very nice job with a very tough case.
I appreciate that. Thank you.
Very much. And we will hear next, I don't know how I lose sheets of paper that are right in front of me. But luckily, I have another one. We will hear next from, if I can find the right one, Attorney Morrison.
Good morning, Your Honors, and may it please the Court. Attorney Morrison on behalf of Mother, and Mother is present here in the courtroom today. Your Honors, I have made two arguments primarily, but I would like to focus the Court's attention this morning to the second argument regarding the failure on the part of DCF to meet their statutory mandate to provide services for this parent. There's no denying that throughout the case, Mother has struggled historically with her mental health diagnoses and substance use. However, equally clear from the record is the department's failure to provide her with adequate services while the case was open. When Mother's social worker was testified at trial regarding any referrals that she had made for Mother from the time when the children were removed in 2018 to the time of trial, when she was asked, did you make any referrals, her response was none. No referrals made for any services. Instead of supporting Mother and providing her with the legally mandated referrals, DCF washed their hands of Mother, sat back, watched her struggle, and waited for her to fail. According to statute, this is not how these cases are meant to go, and it's not an acceptable way for the department to treat a family when their legal mandate so clearly states otherwise. Therefore, termination here was premature.
This brought up at the trial level?
Your Honor, because the reasonable efforts argument was not raised via motion prior to trial, there is, co-counsel has made the argument that this issue has been waived. I would like to point the Court's attention to a slightly nuanced version of this argument, separate from, clearly, if you're trying to argue with the sufficiency of particular services or appropriateness of services offered, that must be raised prior to trial, according to case law. However, according to the cases, adoption of Alona and adoption of Carlos, there's a separate argument to be made that when determining, the judge must determine whether not only is the parent currently unfit, but whether that unfitness is in fact permanent. And when making that permanent unfitness determination, the court must consider whether the services provided to the parent were adequate, and if there were adequate services provided, would that unfitness be
So
remedied?
raised or not, the judge did make a finding of reasonable efforts.
Yes, Your Honor, the judge did find.
Do you agree with the department that we review that for clear error, that that's a factual finding?
Yes, Your Honor, I believe so, that the judge's ultimate finding of whether or not the department made reasonable efforts.
Yeah.
would be reviewed for clear error.
And you're saying it's clearly erroneous to find that there's no support in the record for reasonable efforts being made?
Yes, Your Honor, and also that the judge, when making a separate determination, the reasonable efforts determination is one determination, and then also the permanent unfitness determination, the judge failed to take into account, to conduct the required thorough investigation of the facts, including all of the troubling facts. In this case, the main troubling fact being the failure to make any referrals on behalf of mother.
And what referrals do you say she was entitled to?
Well, I mean, I am no expert on the matter, but I would say mother did testify at length at trial. She testified at some length at trial to how effective in-home services were for her. And when she had the children in her custody, she did work with a parent aide who came out to her home. And during there was a clinical meeting which occurred.
The parent aide having been obtained through DCF or some other way?
The referral for the parent aide there was a referral made for a parent aide, but it was prior to the removal of the children. So the parent aide was provided through DCF.
Okay, so
And
that's an effort. I don't know if it's enough or reasonable, but that's an effort that was made by DCF to help her retain the children, right?
Yes, Your Honor, that was one referral that had been made. However, there was a meeting that happened, I believe it was in July of 2018, during which time they had an area clinical review within the department, and the department suggested that mother be referred to what's called a community service agency, CSA, sort of an escalation of the type of services that this family would require. I also mentioned in my brief that the department social worker had no awareness of something called homemaking services.
Homemaker services, yes, I was troubled by that, although I don't know if that would have been an appropriate referral at that time for her. Do you know that it would have been?
At what particular time, Your Honor?
Well, because this social worker came onto the case late. I don't remember if that social worker, had the children not already been removed when this social worker who didn't know about these services became the social worker? I don't remember.
This social worker, I believe, began working with the family in January of 2018, and spring to summer of 2018 is when these 51A reports began to come in, and the removal ultimately happened in August of 2018. So there was a fairly significant period of time when this particular social worker was working with the family in the home with the children. Okay. And the type of, the homemaking services can be quite extensive. As I mentioned in my brief, they can be up to 24 hours a day. And so for a family, who's struggling with the issues that this family was struggling with, certainly a more robust set of in-home services would have been, beyond helpful. It could have changed the entire course of this case. And I do acknowledge that at the time, unfortunately, that was not raised specifically in, a motion for no reasonable efforts in seeking those particular services. But I do argue that when the judge is looking at the constellation of facts, those troubling facts, in this case, the troubling fact may be that, troubling for a judge who's looking to find unfitness, it's troubling that the department made no referrals.
Now, I don't know when counsel is appointed for various parties in these DCF proceedings, but I would just say to all the appellate counsel who are here, we rarely see this issue preserved. Motions are rarely made below, and we have these rules that we have to apply about preserving it. And I wish people would if these are real substantial complaints, you might want to let the members of the bar who represent parents below know that they should be attentive to this and should be bringing these motions, because in many cases, in this case, the judge did rule on it. We'll have to deliberate about what that means, but it was not, it wasn't, and I'm not saying it's a valid claim even here, given the standard review. I don't know. We'll have to, obviously, we haven't thought about it or discussed it together. So, but I think it would be helpful if these questions were preserved where they are serious, because I have no doubt that sometimes they are.
Absolutely, Your Honor. And this has changed my trial practice on a personal level. But I just would like to also point out the issues that happened with the action plan that was presented to mother. Counsel does correctly point out that there were some items added in there, but the action plan is meant to be a collaborative process with the parent, and the social worker testified she never once collaborated with mother in developing the plan. And additionally, the plan was not, it included tasks that were no longer at all relevant to mother once she didn't have custody of her children, making it a confusing roadmap to regaining custody at best. And I would also point out that mother, despite all of the lack of, support from the department, did, I apologize, I see my time.
Your time is up, but I talked for 30 seconds, so if you want to go for a few more.
Just that mother did engage with services during the pendency of this case. Of her own volition, she was able to identify services and find them somehow, despite no support from the department. And with that, I will rest on my brief if there are no further questions.
Okay, I see no further questions. Thank you very much. Excellent job. We will now hear from Attorney Kelsch.
Good morning, Your Honors, and may it please the Court. I'm Chaz Kelsch for the Department of Children and Families. I'll argue for 8 minutes, and Ms. Fisher-Nair will argue for 7. The record in this case amply supports the lower court's determination that mother and father were unfit because there is a clear nexus between, with respect to mother, her untreated mental health and substance abuse issues and her ability to care for her children, and with respect to father, his substance abuse and domestic violence issues and his ability to care for his children. And mother and father continue to struggle with these issues while the 5 subject children's needs are being met in their pre-adoptive homes. As to mother, her mental health and substance abuse prevented her parenting of the children in part because she was repeatedly hospitalized. Her mental health issues repeatedly kept her from engaging with department services, completing her action plan, visiting her children, and attending court dates.
What evidence in the record supports the finding of the judge regarding the updated action plan with mom? What efforts were made by the department to go through that action plan with mom?
You're talking about after the second removal?
Yes.
So after the second removal, the paragraph 110 of the findings of fact, mother had a new action plan in August 2018. The children were removed on August 2nd, 2018. And most of the steps, many of the steps in the action plan remained relevant thereafter, focused on seeking treatment for mother's substance abuse issues and mental health issues. In the period immediately following the removal, DCF was working with mother repeatedly with respect to missed visits. She missed 10 visits in the 6 months between the removal of the children and the changing of the goal in the action plan, and had mother engaged with services and sought treatment for those issues, it would have gone directly to the heart of the issues that supported the juvenile court's determination. I think the record demonstrates that mother's mental health issues, as I said, repeatedly kept her from engaging with services. She demonstrated repeated hallucinations and delusional behavior, including in front of the children, and her substance abuse frequently interfered with her parenting. She tested positive for drugs at the birth of 3 of her children, and many of her missed visits were directly connected to her substance abuse, including after her July 2019 overdose, an October 2020 visit that was canceled after a sobriety check, and an August 2021 visit, actually during trial, that was canceled because a sangria bottle was visible. And the court's determination that those circumstances were likely to continue was well within its discretion, given her repeated refusal to seek and engage with appropriate treatment. Similarly,
how do you understand the DCF failing to find the 51A about the violence by the father supported, offering him the children after that? Social worker doesn't know that homemaker services are available. How do you understand all this? Do you understand? Maybe you don't know anything other than what I know from the record, but it's not, a moment of glory, any of this stuff, it seems to me, for DCF.
As far as I know, the department was doing the best that it could in a very difficult situation. The department, as Your Honor knows, did refer Mother to services on multiple occasions, and Mother had some difficulty working with the aides to whom she was referred. And with respect to the report of physical abuse that Your Honor referred to, I can't explain to you why that was found unsupported. I'll note only that that report does acknowledge that police saw father hit one of the children. So as a factual matter, I think that...
And does DCF treat that kind of abuse as like within parental rights or something? Maybe you don't know the answer to that. I don't know what to say about it.
The record evidence suggests that the social worker at the time took a different view of the seriousness of the issue, but certainly that's not the department's view today.
Counsel for the mother said no referrals were made, although then when we were discussing it, there was, of course, at least this parental aid. Is it that no referrals were made after the children were removed or inadequate? What referrals were made? Do you know? Do you have any kind of comprehensive sense of that?
My understanding is that the department made a referral to a parental aid in October 2017 and to an intensive program through which mother could get a parenting aid in June 2018. And that mother's argument is premised on the idea that there were no referrals after the children's removal, which I believe to be the case, but I would say that it's not always the case that referrals are appropriate. Mother doesn't argue that she specifically requested certain referrals, and as I mentioned, the period after...
Removal was in August 2018?
Right.
And this intensive program referral in June 2018, did that go anywhere or it's just a referral?
It did. Mother received an aid, but a social worker told mother in July 2018 that mother was to receive a new aid because mother refused to work with the prior aid after the prior aid reported mother's neglect of the children.
I see.
During the period after removal in which there were no referrals, that was a period in which I think the department was within its discretion to conclude that referrals were not the correct step at that time as the department continued to work with mother on what was at that point significant disruption in the lives of the children due to repeated missed visits. Unless the court has further questions, I'm happy to rest on my brief.
Thank you very much.
Thank you.
Very well argued. We will hear finally from Attorney Fisher-Nair.
Good morning. Good morning, members of the panel. My name is Julia Fisher-Nair, and I represent the 5 appellee children in this matter. When this care and protection opened in the trial court in August 2018, the oldest child was 7, and today she's 12. The youngest child was actually born during the pendency of the care and protection, and today he's already 3.
Can you move the microphone over toward you a little bit? I'm sorry. I'm just having a little hard time hearing.
Absolutely. I will first address the mother. Contrary to the mother's argument, the trial court's finding of mother's permanent unfitness was based on clear and convincing evidence of her ongoing inability to resolve her mental health and substance abuse issues, preventing her from assuming parental responsibility at the time of trial. Even before the children were removed in August 2018, there were ongoing issues with mother's mental health and substance abuse that prevented her from being a fit and functional parent to the 5 children, well, at the time, 4 children. The children, as a result of her actions, were often hungry, lived in deplorable conditions, missed numerous days of school, and were often unattended. As the case pended in trial court, mother's unfitness was solidified. Mother was unable to resolve the cause of her unfitness and continued to engage in inappropriate behaviors such as substance abuse. Mother showed up to parent-child visits, often under the influence, nodding off, slurring her words. Most significantly, in May 2019, she gave birth to the youngest child who was born substance exposed child. He had cocaine and fentanyl in his system. Mother did admit to using substances during pregnancy with him, alcohol and cocaine. However, at trial testified that she didn't have a drug dependency issue. As far as mother's mental health, mother was continuously hospitalized during the pendency of the case, and significantly in 2021, the year the trial took place, she was hospitalized for mental health issues for 3 months. On the eve of trial, she was hospitalized for mental health issues, showing signs of active delusions and paranoia and suffering from substance abuse. Your Honors, as far as the reasonable efforts argument made by the mother, I would like to address that as well. I do believe mother waived that argument when she failed to preserve it in the trial court. However, if this court decides to address mother's argument, I would argue that the department did provide mother with the reasonable efforts. Mother was offered various services and was asked to engage in individual counseling during the summer of 2018. Mother declined to do so. Mother admitted to having several mental health diagnoses during the summer of 2018 and stated that she does not believe in taking any medications for those diagnoses. She was referred to a parent aide, and despite the referral being made in June 2018, I believe, she failed to work with the parent aide, and then only, I would say about a week or two before the removal actually took place, did intake with the second parent aide, with whom she initially also didn't want to work with because that parent aide did not have children. As far as the CSA service that was mentioned by the mother, that specific service was not explored during the evidence at trial. There was no explanation for what that was needed for, and that determination only happened July 25th, which was a week before the removal. Mother did, in her service plan in February 2019, Your Honors, you would see that the record clearly shows that although no recommendations were made, DCF was very detailed in outlining service providers that mother could use for each specific task. For example, neuropsychological evaluation, for individual counseling. She had all of those services available to her, so she cannot now say that she didn't get referrals. Mother failed to utilize services during the pendency of the case, and that's really what's at the stem of the children's argument. And, Your Honors, as I'm running out of time, I want to make sure I address the father as well. Notably, most egregiously, father failed to maintain contact with the children throughout the pendency of this case. Besides the fact that he admitted to using substances prior to the care and protection, back in April 2018, he did admit to DCF that he had a history of cocaine use. He also then admitted, of course, in December 2020 that he was engaged in substance abuse, which was all self-proclaimed. He did not provide any documentation supporting that. As far as visits, Your Honors, he disappeared from the children's lives for over 18 months. And even after that, between January 2021 and July 2021, he missed half of the offered visits with his children.
Can I ask you, you represent all 5 children?
Yes, I do.
The little ones, maybe this doesn't apply to so much. Have you spoken with them directly, person to person?
Yes.
Not just to parents, but to the children, foster parents, but to the
Yes.
children? How recently?
I saw most of them in October and one of them in November.
Okay, and I know this is outside the record, but do they remain in the placements that they were in, the pre-adoptive placements they were in at the time of trial?
Yes, they do. They are unfortunately split in 3 pre-adoptive homes. It might be not unfortunate, actually, because the pre-adoptive parents all get along really well, and they are very committed to making sure that all 5 siblings have consistent contact with each other.
But it's the same 3 pre-adoptive homes
Yes.
described in the judge's
Yes.
findings, okay.
Yes, absolutely. And the children did all, except for the youngest, mention to me their desire to be adopted. They love their pre-adoptive parents. They do want to see their mom, so they support the trial court's orders as they were. and they would ask that this honorable court approve and affirm all of the orders from the trial court. Thank you very much.
Thank you. The case is submitted. We will take our traditional mid-morning break, and we'll return for the remaining two cases in 10 to 15 minutes. Good morning. We continue our hearing this morning with number 22-488, THOMOR, Inc. versus Board of Assessors of the Town of Norwood. And we will hear first from, you'd think I would know who we'd hear first from. I think we hear first from Attorney Marino.
Correct, Your Honor. Good morning, Your Honors. May it please the Court, Chris Marino on behalf of the appellants. There are 6 taxpayers here. This is an appeal from a decision of the Appellate Tax Board dismissing these taxpayers' appeals for lack of subject matter jurisdiction. We're asking the Court to remand the matter, to vacate the Board's decision and order and remand the matter for a hearing on the merits. And more importantly, we're asking the Court to adopt the mailbox rule in the application for abatement process.
Can I just ask about the 6 or 7 clients? I understand what happened is that it's your office, right?
Correct.
Put all these same clients into one envelope and gave them to somebody to mail.
Our office mailed them. So we put them all 7 applications go out together. They all go to the town together, and then the same problem happened. That's why all 7 are together.
So they're all in one envelope.
Correct.
And we've never found the envelope. We've never found they never went in. They were never, and apparently never made it to the board.
I mean, that's an issue.
We don't know whether they made it to the board and were lost there, or lost in the mail, or never made it to the mailbox. We have no idea.
We do not know that, Your Honor. But we do know that what the facts show and what the affidavit shows is that they were processed normally, they were put in the mail, they were put there for delivery. We don't know where in the process they were lost. We will stipulate to that. And we don't disagree with the premise of the statute requires delivery.
Counsel, let me talk to you as a follow-up to Justice Massing. On Record Appendix 18, one petition shows that the date that was listed was January 27th, not January 23rd.
Yes, Your Honor, that is. I think that's a mistake of our office. They were all in the same application.
Well, I guess to me that flows to a separate issue regarding the mailbox rule, which if we adopt it in any way in this case, which is the affidavit talks about it's the general office practice to mail them the way she said they were mailed. There's no specific reference that anyone from the office remembers putting them into the mailbox. It's just general practice. Sure. Is that right? Is that a fair?
That affidavit, yes, Your Honor, I agree with that. We send out several hundred of these. They don't remember putting this specific one in. And more importantly, the woman who probably is ill and can't do that. And I understand that. And that may be an issue why the Appellate Tax Board, if it applied the right law, would rule against us on a hearing on the merits. But we didn't even get to a hearing on the merits because the Appellate Tax Board said we had to prove delivery.
Can I ask another question while we're talking about the actual things? The petition in one of these says GPH Newton LLC versus Newton, not Norwood. This is on page RA 18.
Same one.
Well, that probably explains it. That is, it seems like we stuck in the wrong application for abatement. So that would explain why it has a different date. My mistake again. I think it's probably what happened below too, because we just took the same thing we submitted below. So that would rectify why I think they were all in the same.
So do you have a copy of one for GPH Norwood? Because I don't see one in the appendix. Although I think they're named party, right?
They're a named party. It would have been, it must have just been we submitted the wrong one with it. It was collected the wrong one. If it's not in the appendix, then I apologize. We must have submitted the wrong one, but I don't, well, this is certainly a mistake.
Supplement the appendix with a copy of that so that we can see. So you think there is you think there is a petition that says GPH Norwood?
Correct, Your Honor.
And you think it has the date 1/23 on it?
Correct, Your Honor.
Well, if you could submit that just so we could see it, that might help us a little bit.
I'm happy to do that. I just want to clarify, I don't know if that was in the record before the Appellate Tax Board. So I'm happy to, what you have is the record.
It's the petition to the Appellate Tax Board. You think you petitioned on behalf of the wrong party because Newton hasn't responded?
No, I am sure the Appellate Tax Board has the proper petition. I'm just saying, what you have is the exact record the board is looking at, but I will supplement them.
Okay, I don't understand what that sentence means, but maybe your colleague on the other side will know what to do about this. So let me ask you this. I don't know that much about Appellate Tax Board procedure. I assume a motion to dismiss, we take all the allegations in the complaint as true?
Correct, Your Honor.
And is it not the allegation in each of these petitions that this was served on January 23rd?
It is, Your Honor.
So what are we doing here? Shouldn't this be for some later stage in the proceeding?
It should be, Your Honor,
There's
but
no evidence on the other side, there's just some representations of counsel, right?
I agree with that, and that's a way this court could deal with this at this time. You're still going to, at some point, if we're going to go back before the appellate
Well,
tax-
maybe we need to give guidance about how you're supposed to do it, I guess.
Well, I mean, although do we take the facts as alleged because you actually, in opposition, you submitted an affidavit?
But
I mean, do we get, are we actually having, is it actually a summary judgment motion?
But even so,
There's nothing on the other side.
right. There's no actual evidence in the record that says these didn't get here. There's no affidavit, which they could have done. But again, it's a little bit kind of putting the cart before the horse.
Why is your position not that these were filed? Okay, how can I put this? The postmark rule applies for things received after February 3rd, right?
Correct.
If we apply the mailbox rule, does the mailbox rule have a +3 days or something for a date of, or is it the date of mailing?
No, the reason why we need the mailbox rule is it's a presumption of delivery.
Delivery when? How many days later?
It doesn't have a time, but under the postmark rule,
I'm not interested right now in the postmark rule.
Right.
I'm interested in the mailbox rule.
Right.
If you mailed these on January 23rd,
correct.
and they were received by the ATB on January 27th, would their filing date be the 27th or the 23rd?
The 23rd, but just to be clear, we're
Okay,
sending these to the town.
Why would it be the 23rd? Because if they are delivered, if they are received after February 3rd or whatever it is, then the date is the postmark date.
Correct.
But if they're received before February 3rd, I don't think the rule tells us anything about a postmark.
If they're received before, they'd be timely. But just one quick point.
What date would they be timely? Would they be the date of mailing or the date of receipt?
If they're received, it's the date of mailing. The postmark rule says if you send it and it gets delivered there and it's received by the town, it's the
I
date
think
of
it
mailing.
says if it gets delivered there after the deadline, it's the date of postmark. How about if it's delivered there before the deadline?
I guess the rule's silent on that, but I don't know that if it's before the deadline, you're timely, there's no.
Okay, but mailbox rules, I don't know what, you're talking about the common law mailbox rule. So maybe you need a statute to do it. I've seen rules that say you add 3 days for mailing, or, do you know what I mean? It's not just a presumption that it was delivered, it's a presumption that it's delivered within a certain number of days or something, isn't it? Or that's not common law, that's only...
I think that's.
I mean, I've seen rules
of
of court, so when I used to practice, I saw rules of court, like if you have it postmarked by such and such a day, then I guess the postmark counts, I don't know. But they give you, like for service, you get an additional 3 days.
From the date on the certificate of service.
Yeah.
Can I ask you, because this goes back to the question of the dismissal stage, are we following the rules of civil procedure or are we following the CMRs?
Well, so at this point, in the application of abatements to the town, you're not filing, I don't think you're following either of those. That's the thing.
If that's true, then why do you suggest that there can't be evidence taken at the motion to dismiss stage? Why can't the board look at the petition as evidence? Why can't the board look at the affidavit? Why can't the board look at the submission in opposition as evidence?
I think the board could, but the board...
Why didn't they do that in this case? They looked at your affidavit and they said, okay, we have the mailbox rule, we're going to give you it was January 23rd, but we also have the board's submission, or not the board, the town's submission, that they never got it. Why can't they consider that?
That's not sworn evidence, not an affidavit, it's just a representation of counsel, right?
That's not sworn evidence, and I guess the answer to that, on a hearing on the merits, the board could submit all that. What the board has required the taxpayer to do in this instance is to show delivery, which the taxpayer is never going to be able to do, or hardly ever going to be able to do when it sends it by regular mail. Right, we could send it by certified mail, but the statute doesn't require certified mail. So it's putting an onus on us to do something that really the taxpayer is unable to do, And if you have the postmark rule, which says, hey, we're going to treat it as timely filed if it gets there, and you presume delivery, what you wind up with is a situation before the appellate tax board where it's having a hearing on the merits and the parties can come in and put their case in. What I think you're suggesting, Your Honor, is exactly what we're trying to have here. Have the board have a hearing on the merits as opposed to...
Okay, but on the merits of whether they were mailed or on the merits of the abatement?
I think that would be on the merits of both. On the merits of whether it was delivered.
Okay, yes. So now let's go through how that's supposed to work. Let's say I agree with you. Motion to dismiss is the wrong time to be contesting the fact. You say it was filed on January 23. On the face of it, there's jurisdiction. Now we go forward. They say this has to be dismissed. We did not receive it by the deadline, nor is there a postmarked thing that we received after the deadline. In fact, we never received it.
Correct.
Okay. Now, and let's say it's their burden to show it should be dismissed, although I guess you'd have to put in some evidence that was sufficient to support a finding, at least, that it was mailed.
Correct.
All right. So we don't know what they would put in. They've never put in an affidavit. Presumably, what one would like to see, and I don't know if they can find someone who will say this, we searched everywhere. We looked high and low. Here's how we process things when they come in. We looked behind all the filing cabinets. We did whatever we do in Norwood, and it was never received here. It's a little tricky, right? Because people do lose things, right? But all right. So they say that. You say, let's pretend you had a really good affidavit that said, I put it in the mailbox. I took this, I remember that day. An abatement might be just some taxpayer, right? They'll remember if they mailed it or not, because there is only one of them. Yeah, I took it down, I mailed it at the, Brookline Village Post Office or whatever. That's where I mail stuff, and I took it. So now the court has an affidavit from someone saying I mailed it, and an affidavit from someone saying I didn't receive it. How are they supposed to assess?
Well, I think the board does what it does in every fact finder. There would be three opportunities. The board could say, nope, I disagree, I don't believe the taxpayer, you never mailed it. The board could say, I disbelieve the process at Norwood, you got it. Or it could say it was lost in the mail. First, if it was lost in the mail, the taxpayer loses. If the board finds
it's lost in the mail, the taxpayer loses?
I wish I had a different answer, but I think that's what the law says. I think that's what the postmark rule says. It has to be delivered. Or the board could find, based on this evidence, it was delivered. And you lost it. And I don't know how the board's going to resolve it, but that's a hearing on the merits, and the taxpayer doesn't even get, under the way it's set up now, the taxpayer doesn't even have the right to that type of hearing. And that's what we're asking for, to give the taxpayer their day in court.
So how are they supposed to, okay, so the person comes in and is very honest and says, I looked everywhere, I didn't find it. And they find that seems credible. That doesn't really mean it wasn't lost at Norwood, right? Maybe one day somebody was collecting up papers, or janitors come in, or, right, who the heck knows?
But at that point, you're talking about a hearing, and you're talking about counsel's ability to cross-examine the people there.
I'm saying maybe we have to remand this, but I'm trying to figure out how we instruct the ATB to hold this hearing. See, I think there should be although I see what you're saying, a presumption that things that are mailed are delivered, right? You said they could find lost in the mail.
Correct. They can rebut the presumption. Absolutely, it's a fact fight.
So you put in that it was mailed, and they say, we believe that. But they're allowed to not believe it, is that right?
I think we have the presumption, so I think at this point, the burden would shift to them to show that it wasn't there.
Well, if it's true that you mailed it. You didn't take a picture of it, you didn't send certified mail, but I'm willing to agree you don't have to do that.
Correct.
But then the question is, how do you prove that you mailed it?
Correct.
Someone coming in and saying, I remember it clearly would be good. What you've got is not as good, but it's something, right? You could find based on that. I find that, maybe you'd want to bring in more than just this person. Who runs the mailroom? Who runs the law firm? How is it set up? What's the system? What are the controls? And them too.
We could do all that, Your Honor.
But if you're both telling the truth, isn't it, what are they supposed to do? Or they can't, is it conjecture? I surmise that it must have been lost at Norwood. I've worked in a city before, and I know that bureaucracies lose things more than law firms. Or, right?
Your Honor, fact finders find difficult facts all the time, and I think the board's well-positioned to be hearing these and determining these. They can serve as the fact finder. The parties will put their submissions in. They'll have an opportunity to cross-examine the other side. They'll do all that.
But your position, I want to make sure we're clear if we do what we do. If they rebut the presumption by bringing somebody from the town that says, we didn't get it, that's it. You agree that the postmark rule would apply, period.
If the fact finder finds that, I agree with that, Your Honor.
If they find if they find they never received it?
Yes.
And is it sufficient evidence to have someone come in and say, I mean, you're proving a negative, right? But is it sufficient evidence? They bring in the head of the mail recipient desk or whatever, whoever's the clerk or whoever stamps it, and they're like, this stuff comes in all the time and I do X with it if I get it. And
if they put in this, my time's up, but if they put in the sufficient process and they went through that process rule and they can establish all that and it's persuasive to the board that it was lost somewhere before it hit the tax department, I think we would lose at that point.
Very interesting.
Thank you.
Thank you, Your Honors.
Thank you very much. Interesting. I think it's a really interesting case, but then I'm a judge. We will hear next from
And a taxpayer.
And a taxpayer. I am that. From Attorney DeCourcy.
Good morning, Your Honors, and may it please the Court. Stephen DeCourcy, representing the Board of Assessors of Norwood. I'm here today to ask that the Court affirm the decision of the Appellate Tax Board dismissing the appeals that were filed by the various taxpayers
There's no evidence in the record that you didn't receive this, so how can they dismiss it?
Well, there is evidence in the record in terms of, let me just address a couple things here. First of all, Chapter 59, Section 59 puts the burden on the taxpayer to show receipt, or should, in this case, show delivery of abatement applications. To Justice D'Angelo's question, the rules of civil procedure do not apply to the Appellate Tax Board. In fact, the Appellate Tax Board's rules of procedure, Rule 831 CMR 1.37.
Wait, say that again?
831 CMR 1.37. The board reserves the right to make hearings and proceedings as informal as possible to the end that substance and not form shall govern, and that a final determination of all matters before it may be promptly reached. Well, that's exactly what happened here.
And that goes to the issue that you bring up regarding waiver, that the taxpayer, once the finding came out, should have sort of appealed or asked for findings of fact. Is that correct?
That's correct. That's correct, Justice D'Angelo. And in fact, what happened here, even within the affidavit, and I recited the email from Attorney Witkin where he said that the applications were somehow lost and sent applications on February 28th, 2020, 25 days after the deadline. In the affidavit...
This is the formal procedure?
Yes, it is.
Except as here and otherwise provided, the practice and procedure before the board shall conform to that heretofore prevailing in equity causes in the courts of the Commonwealth prior to the adoption of the Massachusetts Rules of Civil Procedure, which I think bears looking into since we've had them for about 45 years, but
It's a demur. You've got to file a demur.
Okay, you're right. But in a demur, you would take the allegations of the complaint as true. And the complaints here, petitions, all say it was filed on January 23.
This again goes to subject matter jurisdiction.
I agree with that.
And so you can go outside the face of the petition.
Okay, and if you had submitted an affidavit, that would be one thing, but all you submitted was a brief by counsel saying we never got it. What is that?
What we submitted is what was received by the assessors, but let me just point out...
You did not submit an affidavit. You submitted no evidence. Do you agree with that?
We submitted evidence of what we received.
How? Where is the evidence?
Well, the applications, the date that they were received was through an email on February 28th, but there's an affidavit...
I'm sorry, how did you, by attaching an email to a brief, that's the evidence you put in?
That's the evidence of the date of the receipt of the applications, the denial notices...
Not attached to an affidavit?
It's not an affidavit, Your Honor. No, that's right. I can cite to an affidavit that the taxpayer submitted.
I agree with that.
Okay, and within that affidavit, they stated that on or about February 21st, 2020, Tim McDonough, who's the chairman of the Board of Assessors, sent an email indicating that Norwood had not received the applications for abatement. That right away, even if you were to accept the mailbox rule, that puts in evidence that there was no receipt, and then it's up to the board to determine whose burden it is, and it's the taxpayer's burden to show receipt. They showed that didn't happen. And
how can it be the taxpayer's burden to show receipt at your office? I don't understand that.
That's what the statute calls for. That's the allocation of the burden.
They send it by certified mail.
Which they didn't hear.
I understand, they don't have to, but they do.
That's right.
Okay? And you say you never got it.
Right.
How can they prove you got it? I don't understand.
Well, the certified mail receipt, there would be a signature on the certified mail receipt.
That's return receipt requested. I didn't say return receipt requested. I said certified mail.
Well, and sorry, I take certified mail to typically mean that it's return receipt requested.
Without a return receipt, it's just certified mail. They've got a number, tracking, whatever. How do they prove delivery?
Well, they proved delivery by requesting from the Board of Assessors, which they did here 17 days after the deadline, please send us our date stamped copies. The assessors said we'd never received any applications.
Okay, so but you say the burden is on them.
Absolutely on them.
And that's in the statute.
That's in the statute. I mean, it's in case law, and there's some difficult results.
Their burden is to prove what happened inside your office. How can they do that? I don't understand.
They're to prove that the assessor received the application.
Okay, so now they use FedEx.
Right.
And FedEx says it was delivered.
Right, and they use the FedEx signature, and that's...
No. No signature was received. They just say, yeah, we left it right outside the office. Yeah. And you say, well, we never got it.
Yeah, and that becomes a question of fact of what the FedEx delivery person did.
And how exactly is the board supposed to resolve that question?
On the question of the FedEx delivery?
Yeah.
Well, they'll take what the FedEx receipt said, where it was delivered, how it was addressed. Here, we don't have anything. Just bear in mind, the taxpayer chooses the mode of delivery. So if there's any issue here in non-delivery, it's because of choices the taxpayers made, not the assessors.
The statute actually makes the choice that they can do it this way. It could say you have to get a return receipt. It seems to me that if they took a picture of him sliding the thing into a mailbox. Okay, let's say there was a photograph. It's much better than the affidavit he has. With an affidavit attached, this is a true and correct copy of a photo that I took as I mailed it. And you said, just like here, we never got it. Seems to me that there's a presumption if he mailed it that it was delivered. Do you disagree with that?
Well, I disagree to the extent that Chapter 59, Section 59 gives them the benefit of that presumption, because the Section 59 requires that the postmark be examined to determine...
No, if it's delivered late.
No, that's right. If it's delivered late...
He mailed it on the 23rd. That's 10 days for it to get to you before the deadline, if it was mailed. So this is a photo of me mailing it. I'm sliding it into the mailbox, and there's a date stamp on it. It says January 23. And you just say a month later, we never got it. You don't think he's met his burden? But I mailed it. Look, I'm allowed to send it first-class mail. That's why I took a picture of me putting it in a first-class mailbox. You don't think he gets a presumption?
In that situation, I don't. If the assessors say they never received it, or if there's evidence, as there was here, the taxpayer sent applications February 28th. Why would they do that if there was a question about...
After you told them that you hadn't received them, they'd send you copies. That doesn't do anything for me, really. I'm asking the question about what the rules are. I'm not saying their affidavit is good enough or not good enough. I'm saying it's a photo of someone putting it in the mailbox on January 23rd, as the rules permit. Well, I couldn't afford return receipt requested because until I get this tax abatement, I don't have any money. So I just used a first-class stamp. It's 50-something cents. I can't believe that, but it is. But I took a picture of it because I thought, I hear Norwood is always saying they lose stuff. They never got stuff. So I took a picture. And you don't think that the tax board can say, look, he mailed it first class. There's a common law presumption that you mail something first class, it's delivered. Now, you can rebut it, but the presumption counts in the absence of you rebutting it.
If that's all there was, the taxpayer saying nothing, even from the taxpayer acknowledging that applications were lost, which they said here, and nothing, no reference through an affidavit acknowledging receipt of something from the town, that's a different story. That's not what is before the court here today.
Well, I don't want to help you, but I'm going to. The board could accept that picture as valid proof of receipt, correct? They're making a finding of fact based on what's submitted. They could do that, correct? Even at a motion to dismiss stage.
Yeah, that the board in weighing...
Judge D'Angelo has never met a tax assessor.
Well, I'll go back to Shakespeare, but...
Yeah, in the absence of anything else, I suppose the board could. However, again, that runs up against Section 59's requirement that every single phrase and word within Section 59, the taxpayer has to show compliance with that. But you're right, through an inquiry without anything from the assessor, I suppose it's possible.
Now, let's get back to this case and talk about the waiver, because you spent a substantial portion of your brief on that.
That's right.
What should the taxpayer/attorney for the taxpayers have done when he got receipt of that decision of the board? What should have he done to perfect it?
Well, the board, in its decision, there are two things it put in the margin. And one thing was, either party may request findings of fact and report, and either party, or the appellant in this situation, may file a notice of appeal. Well, they filed the notice of appeal. They didn't request the findings of fact and report.
Well, here's my issue with that, or question is, what would that have done?
Well, what that would have done is, and again, through the board's practice, the board routinely issues findings of fact and report on motions to dismiss that are allowed. And what that would have done is, beyond what was in the affidavit, there was inquiry from the appellate tax board at the motion hearing as to what happened. What happened on February 21st? Why were emails sent on February 28th? And there are things that aren't on the record here because they're not in the findings because they weren't requested. But there was a request made on February 20th, and I realize this is outside the record.
But a hearing would be to get evidence, because you need evidence, it seems to me, before you can dismiss this.
Well, the taxpayer has the burden of showing that the board has jurisdiction over this matter.
Yes,
and typically it's done through the date-stamped application, the appeals filed on time, you have the denial date, you have the date of mailing of the tax bill.
If I look, is there some place I can look to see that a motion to dismiss before, other than just the words of that rule, that a motion to dismiss before the board doesn't take the allegations of the petition as true?
Well, just in the general rules of subject matter jurisdiction, Justice Rubin, you can go outside of the face of the complaint.
You didn't submit any evidence. I know you say you submitted an email, and you said a bunch of stuff in the brief, but that's not evidence. You agree with me that's not evidence, right?
That's not evidence, but it's what the board could consider as part of its decision.
How can it consider something that isn't evidence? I don't understand.
Well, the affidavit, the opposing affidavit was considered by the board. If the board can't consider beyond the petition... The board can look at
their affidavit and say, they report I guess it's a party admission of the other side saying to us on the phone, we never got it. We find as a fact that they never got it. You think that's a permissible finding based on their affidavit?
Yes, I do. In fact, again, this affidavit was submitted to the board, but again, this goes to my argument on the non-request for findings, and I cited the Rhoda Realty Trust case in my brief, and that was a jurisdictional issue. It was a motion to dismiss. The board
granted the motion to dismiss, and the Supreme Judicial Court said that the taxpayer was content to submit affidavits and to argue. They didn't ask for an evidentiary hearing, and there were no findings. And so there was
I read that case, and I'm slightly confused, frankly, by what the SJC meant happened at that stage. So in this situation, you file the motion to dismiss. What is the taxpayer supposed to do upon your filing of the motion to dismiss? Are they supposed to, at that point, ask the board, we want to submit evidence in opposition to this, or do they just submit papers? What did they agree to in Rhoda? That was the part I'm sort of mystified by.
Well, in Rhoda, there was affidavits, and there was an opposition submitted, and again, there was no findings. So at that point, there wasn't perhaps an adequate record for the SJC to look at. But here, you have a similar situation where you have a decision of the Appellate Tax Board, you don't have a request for findings. So what's before the court is applications that were received on February 28th, 25 days afterwards. You have an affidavit from the taxpayer acknowledging that the town reached out to them by email, because that's what came out at the hearing, so we never received it.
The basis of the Appellate Tax Board's decision is clear on its face. Nothing in the opposition supports the conclusion that the postmark rule may be satisfied in the absence of evidence of delivery of the abatement applications to the assessors. So they aren't saying you didn't lose it. They're saying what they put in wasn't good enough to show it was delivered, right? They're not saying we believe you. They're saying you didn't even tell us anything about delivery, which is how we get here. The question is there affidavit that says, if it says this, it was mailed? Is that good enough that we should say that's enough to show delivery? You can rebut it now. That's the whole question, isn't it? It's a purely legal question.
Well, a legal question in terms of was Section 59 complied with in the absence of a postmark, and the board said no.
Okay. All right, a very, very interesting case. Excellent arguments by both sides. They are very helpful to us. The case is submitted. Before we hear our last case, we're going to reconstitute our panel. So we will take a very brief recess, and in a few moments, the panel will be reconstituted. All right.